It is the most ordinary moment imaginable. You are pulled over on the side of a road for something small, a taillight, an expired tag, a turn you made without the blinker. You are calm, you are cooperative, you have done nothing that any reasonable person would call a crime. And then the officer standing at your window says two words that change the entire nature of the encounter. Step out. Just step out of the car. And in the 2 or 3 seconds that follow, you are going to make a decision, whether you realize you are making one or not. Most people make the wrong one. Some refuse because they believe they have a right to. Others obey, and in obeying, hand over far more than they ever had to. Both of them just made the single most common mistake there is at an American traffic stop, and both of them are about to find out how much that mistake can cost. Here is the truth that catches almost everyone off guard. The power of that officer to order you out of your own car when you have committed nothing more than a minor traffic violation is not new, it is not a fluke, and it is not up for debate. It came from the Supreme Court of the United States, and it has been settled law for longer than many people watching this have been alive. But, and this is the part that matters most, the law that lets him order you out is far narrower than people think, and what you are still allowed to do in that moment is far greater than people think. The gap between those two facts is exactly where people destroy their own case. By the end of this video, you will know precisely where that line sits, and you will know the one mistake to never, ever make when you hear those two words. Before we go one step further, one thing. This channel exists to put Supreme Court decisions, new laws, and the real boundaries of your rights into your hands the moment they matter. Not 3 weeks later when a headline finally drifts past you, not after you have already needed the information and stood on the side of a road without it. The instant the law that governs your daily life becomes something you can actually use, the breakdown is waiting for you right here. If that is the kind of knowledge you want in your corner, subscribe right now and turn on the notification bell. It takes you 2 seconds and it costs you nothing. Now, let us talk about what the court actually said and what it means the next time you hear the words, step out. To understand the mistake, you first have to understand the collision underneath it, because there are two ideas crashing into each other in that moment, and most people only know about one of them. On one side sits the Fourth Amendment. It guarantees you the right to be free from unreasonable searches and seizures. When the police stop your car, that is a seizure. You are not free to drive away. The Constitution does not take that lightly, and for good reason. On the other side sits a different and very real concern. A traffic stop is one of the most unpredictable encounters in all of American life, for the driver and for the officer alike. An officer walking up to a stopped car does not know who is inside, what they are carrying, or how the next 30 seconds will unfold. And those two truths do not sit comfortably together. A free person, stopped for a burned-out bulb, has every reasonable expectation of being left largely alone. An officer, approaching a metal box he cannot see into, has every reasonable interest in controlling the encounter. Somewhere between those two interests, a line had to be drawn, and the Supreme Court is the body that drew it. The question was never whether your rights matter. They do. The question was narrower and sharper than that. When your right to be left alone collides with an officer's interest in his own safety, which one bends first, and by how much? That is the question that produced the rule you are about to learn. So the question landed in front of the Supreme Court, and it is a question that should make you sit up. Can an officer order you, a person who has done nothing but commit a minor traffic violation, to get out of your own car? Not because you are suspected of a crime, not because you made a furtive movement, not because of anything you did at all, beyond the small infraction that got you pulled over in the first place. Can he simply command you out of your seat and onto the pavement with no additional reason whatsoever? And here is the answer that surprises nearly everyone who hears it for the first time. Yes, he can. And the court did not consider it a close call. Cases like this do not begin in marble courtrooms. They begin exactly where yours would, on an ordinary street over something forgettable. In Philadelphia, in 1970, 2 officers pulled over a man named Harry Mims for driving with an expired license plate. An expired plate. That is the whole reason for the stop. One officer walked up and asked Mims to step out of the vehicle and produce his license and registration. Mims complied and got out, and as he stood there, the officer noticed a large bulge under his jacket. Concerned it was a weapon, the officer patted him down, and it was. Mims was carrying a loaded handgun without a license. He was arrested and convicted. Now here is where it gets interesting, and where it should genuinely surprise you. Mims challenged it, and the Pennsylvania Supreme Court agreed with him. That court ruled that ordering Mims out of his car when there was no reason to suspect him of anything beyond an expired tag was itself an unconstitutional seizure. By that logic, the gun was discovered only because of an illegal command, and it should have been thrown out. For a moment, The law actually sided with the driver. And then it reached the Supreme Court of the United States, and the Supreme Court reversed it. In a 6-3 decision, the court held that once a vehicle has been lawfully stopped, an officer may order the driver out, and the Constitution permits it. The court called the additional intrusion of being asked to step outside your own car, and listen to these exact words, de minimis, a trivial matter, so minor in the court's view that it does not even require a reason. And the rule did not stop with drivers. 20 years later, in 1997, the court took up a case called Maryland against Wilson, and the question this time was about passengers, not the driver who committed the violation, but the person sitting beside him, who may have done nothing at all. And in a 7-2 ruling, the court extended the same power. An officer may order passengers out of a lawfully stopped vehicle, too, with no individualized suspicion of any kind. The reasoning was the same. The danger of a traffic stop justifies it, and the intrusion on a person who is already lawfully stopped is, in the court's judgment, small. 2 justices dissented, warning that wholly innocent passengers should not be ordered about simply because the driver rolled through a stop sign. But they were in the minority, the rule stood, and it is the rule today. And it is worth sitting with how sweeping that is for a moment. The passenger in that car may be a friend catching a ride, a coworker, a child being driven home from school. They committed no violation. They were not even driving. And yet, under this rule, an officer may order them out onto the shoulder of a road, in the cold, in the rain, in front of every passing car, for no reason particular to them at all. The 2 dissenting justices saw exactly that, and said so plainly, arguing that wholly innocent people should not be commanded about simply for the misfortune of sharing a car with someone who failed to signal a turn. Their warning did not carry the day. The power remained. And you should know it applies to you, whether you are the one behind the wheel or simply the one along for the ride. Here is the core of it, and every word matters. Once you are lawfully pulled over, an officer may order you and anyone else in the vehicle to step out, and he does not need any suspicion that you have done something wrong to do it. Let me break that into plain language. When an officer says step out, that is a lawful order. You do not have a right to refuse it. You cannot debate it on the roadside. You cannot win that argument standing on the pavement, and trying to is one of the fastest ways to turn a small problem into a large one. The order to exit is the officer's to give. That much is settled, and it is not the part of this you should be fighting. But hold on to that phrase, the order to exit, because it is doing precise work. The court gave the officer the power to change where you are standing. It did not give him the power to change who you are or what you may keep. What was decided is small, specific, and exactly as limited as the words the court actually used. Step out. 2 words. 1 door. The rest of the house is still yours. Now, here is where most people watching a video like this make the mistake that turns a settled rule into a personal disaster. You hear all of that, and you draw exactly the wrong conclusion. You think, if he can order me out for nothing, then once I am out, he can do anything he wants. The protection is gone. The fight is over. I might as well let him search, answer his questions, and get it over with. Stop right there. Because that conclusion is false. And believing it is how people give away rights they fully and completely still have. The order to step out is one of the narrowest powers in all of traffic stop law. It lets an officer move your body from inside the car to outside the car. That is all it does. It is not a key to your glove box. It is not permission to search you. It is not a waiver of your right to stay silent. It is a relocation, and nothing more. Those 2 ideas, that you must step out and that stepping out surrenders nothing else, are the heart of this entire video. You can comply with the order and protect every other right you have at the very same time in the very same breath. People make 2 opposite mistakes here, and both are fatal to their position. So let us walk through them, because you need to know each one cold before you are ever standing on the side of a road trying to remember it. The first mistake is the one that manufactures a crime out of absolutely nothing. It is refusal. You believe, sincerely, that you have a right to stay in your car, so you cross your arms and you say, I know my rights, I am not getting out. You have just handed the officer something he did not have a moment ago. Because the order was lawful, your refusal to obey it is not a protected exercise of your rights. It can become obstruction, it can become resisting, it can escalate a calm encounter into a physical one in seconds, and now you are facing a charge that has nothing to do with the taillight that started all of this. Read that twice. The driver who refuses to step out does not protect himself. He invents a brand new offense and pins it on his own chest. And understand why this trap is so easy to fall into, because it does not feel like a mistake at all. It feels like courage. It feels like standing up for yourself. Like the people you have watched online refuse and lecture and demand badge numbers and walk away heroes. But the law does not reward that performance here. It punishes it. There is a world of difference between asserting a right you actually have and refusing an order you are actually required to obey. The first protects you and gives a prosecutor nothing. The second hands that prosecutor a gift wrapped in your own defiance. Knowing which is which, in the heat of the moment, with the lights flashing behind you, is the entire skill. Compliance with the order is not surrender. It is the smartest move you can make, and it costs you nothing, because, as you are about to see, your real protections live somewhere else entirely. The second mistake is the mirror image of the first, and it is just as destructive. It is overcompliance. It is the belief that because you had to step out, you now have to allow everything else. This is the trap. Stepping out of your car is not consent to search your car. Let me say that again, because it is the single most misunderstood point at any traffic stop. When an officer orders you out, that order by itself gives him no authority to search the vehicle. A search of your car still requires one of a few specific things: your consent, probable cause to believe there is evidence of a crime inside, or another recognized exception. The act of you standing on the pavement provides none of those, and the same is true of your body. An officer cannot pat you down for weapons simply because you are out of the car. A frisk requires its own separate justification, a reasonable suspicion that you are armed and dangerous, a standard the court set long ago in a case called Terry against Ohio. In the Mims case, remember, the frisk was justified only because the officer saw a visible bulge. No bulge, no automatic frisk. Stepping out opens the door to none of this on its own. People who assume it does are giving away the store before the officer ever asks for it. This is the mistake that costs people their cars, their freedom, and sometimes years of their lives. And the cruelest part is that it is almost entirely self-inflicted. The officer did not gain the right to search. The driver simply behaved as though he had, and behavior, on a roadside, has a quiet way of becoming permission. Every door you open with your own hands, every assumption you act on without being asked, becomes a fact the officer is entitled to use. The rule that forced you out of the car is small. The rights you keep while standing beside it are large. Do not trade the large for the small out of nervousness and the simple urge to seem agreeable. And now, picture this. You are standing beside your car, and the small mistakes begin to stack, one on top of another, each one a brick the officer can build with. He asks, in a friendly voice, "Where are you coming from tonight?" And you answer, "Because it feels rude not to." Then you remember your registration is in the glove box, and you turn and reach back into the car to grab it, fast, without a word. And then he asks the real question, the one this whole encounter may have been building toward. "Do you mind if I take a quick look in the car?" And you, eager to seem cooperative, eager to prove you have nothing to hide, say sure. In the space of 1 minute you made 3 separate mistakes, and the last one erased every protection you had left. Before I go further, I need to say this plainly because it matters more than anything else here. None of this is legal advice. This is general information about how the law works. The exact rules that will govern your stop depend on your state and on facts I cannot possibly see from here, and they vary more than you would believe from one state line to the next. When your rights are actually on the line, you talk to a licensed attorney in your state. Full stop. Now we arrive at the single most dangerous moment of the entire encounter, the moment that no Supreme Court ruling will ever save you from, because you are the one who pulls the trigger on it. It is the consent question. After you have stepped out, after the small talk, the officer asks if he can search your car. And he asks it in the most reasonable, most disarming way he can. "Do you mind if I take a look?" He is polite, he sounds like he is just being thorough, and every cooperative instinct you have screams at you to say yes. Do not say yes. The instant you say yes, the instant you say sure, go ahead, every protection you carefully kept by stepping out calmly and saying nothing collapses in a single word. You have given consent, and consent is the master key. It opens the glove box, the trunk, the console, your bags, all of it, and it cannot be taken back later in a courtroom. You stepped out because the law required it. You do not have to consent to a search because the law does not require that at all. Those are two completely different things, and the entire game lives in the space between them. So here's your protocol, step by step, for the exact moment you hear those 2 words, and notice how every step lets you obey the lawful order while surrendering nothing else. Step 1. When the officer says step out, do not argue, do not negotiate, do not ask why, and do not refuse. Comply. Open your door and step out calmly. The order is lawful, and fighting it only builds a case against you. You are saving your real stand for the moments that actually matter. Step 2. Narrate your movements and keep your hands visible the entire time. As you reach for the door handle, as you swing your legs out, move slowly and deliberately. If you need to undo a seatbelt, say so. Sudden, silent movements are exactly what turn a calm officer into a frightened one, and a frightened officer is the most dangerous thing on that roadside. Eliminate every surprise before it can happen. Step 3, and this one is critical. Once you are out, do not reach back into the vehicle for anything. Not your wallet, not your registration, not your phone. If you need a document that is inside the car, tell the officer where it is and ask him how he would like you to retrieve it. Reaching back into a car you have just been ordered out of is one of the most misread movements in any stop, and it has ended encounters in ways no one wanted. Let the officer control how anything comes out of that car. Step 4. Stand where you are directed and stay calm and quiet. You are not required to fill the silence. When he asks where you are headed, or where you are coming from, or whether there is anything in the car he should know about, understand that these are not friendly questions. They are an invitation to build a case, brick by brick, out of your own words. You have the right to remain silent, and silence is not rudeness. It is one of the most powerful legal tools you possess. Use it. Step 5. If he asks to search, decline calmly, briefly, and firmly. Do not argue. Do not lecture. Do not recite the MIMS case at him, because it has nothing to do with a search, and quoting it will only confuse the moment. Simply say, "I do not consent to a search." If he answers with, "If you have nothing to hide, why not let me look?" recognize that for exactly what it is. It is pressure, engineered to make your refusal feel like guilt. It is not guilt. It is your right. And the more briefly you exercise it, the stronger it is. Say your sentence, then stop talking. Step 6. If you are being frisked, do not physically resist, but state your position out loud. A pat down for weapons requires a reasonable suspicion that you are armed and dangerous, and you may not agree that he has it. Do not fight him with your hands, fight it with your words. Say, clearly and loudly enough for his body camera to capture, "I do not consent to this search." Then let it happen, and let the record carry your objection forward to a place where it can actually be argued, in a courtroom with a lawyer beside you. Step 7. Know when the stop is supposed to be over. An officer cannot hold you on the side of the road indefinitely to go fishing. Once the purpose of the stop is complete, the citation written, the warning given, he needs a real reason, a reasonable suspicion of something more, to keep you there. The court was clear about this in a case called Rodriguez. If the business of the stop is finished, and you are simply being kept around in hopes that something turns up, you may calmly ask, "Officer, am I free to go?" Asking that question, politely, forces the moment to define itself. Step 8. Document everything before you drive 5 more miles. The instant the stop ends, pull over somewhere safe and write it all down while it is still sharp in your mind. The time, the location, the officer's name and badge number, the exact words that were exchanged, whether you were ordered out, whether you were asked to consent and what you said, whether you were searched or frisked, and what reason, if any, was given. Write down the small details because those are the ones that win cases. Human memory fades fast and it fades selectively. Specific notes, written down within minutes, are what attorneys build winning cases on. Vague recollections are what cases are lost on. And one more thing, especially if you happen to be the passenger and not the driver. Every step you just heard applies to you too. The same court that lets an officer order the driver out lets him order you out, even though you were not driving and broke no law. So the same discipline holds. Step out calmly, keep your hands visible, stay quiet, and consent to nothing. Your rights never belong to the driver. They are yours, and they travel with you onto the pavement. So understand where this leaves you, because it is not where the fearmongers want you to believe. The Supreme Court did decide, decades ago, that an officer can order you out of your own car over something as small as an expired plate, and no amount of arguing on the pavement will change that. That part is not yours to win. But the court did not decide that stepping out strips you bare. It does not. The moment you are standing on that roadside, you still hold your right to refuse a search, your right to stay silent, and your right to leave once the stop is done. The order took you out of the car. It did not take your rights with you. The officer controls whether you step out. You still control almost everything that happens after. The single mistake to never make is forgetting that those are two entirely different things.